I welcome members to the 8th meeting in 2013 of the Subordinate-Legislation Committee and would ask members, as always, to turn off mobile phones. Agenda item number 1 is draft instruments not subject to any parliamentary procedure. We begin with the Public Services Reform Functions of the Common Services Agency for the Scottish Health Service Scotland Order 2013 Draft SG 2013-12. The order must comply with various restrictions listed in Section 18 of the Public Services Reform Scotland Act 2010. While the general objective of the order is, of course, a policy matter, whether the policy can be achieved through this process is properly a matter for the committee to consider. If the various restrictions are not met, then the policy would have to be delivered through bringing forward a bill. The legal advisers have identified a number of issues regarding the various tests set out in Section 18 of the Public Services Reform Scotland Act 2010 for members to consider. If members wish to obtain more information from the Scottish Government about these matters, the committee could do so by taking oral evidence from the Scottish Government at a later date. The procedure set out in the 2010 Act specifically provides the opportunity for the committee to consider issues at this stage and to comment before the order is laid for approval by the Parliament. Does the committee therefore agree to explore further with the Scottish Government whether the effect of the order is proportionate to the policy objective, the order strikes a fair balance between the public interest and the interests of any person adversely affected by it, and the order removes any necessary protection? Agreed. And on that basis, we would expect to see officials fairly soon, probably next week. Does the committee therefore agree to explore these issues further by taking oral evidence from the Scottish Government? Agreed. Thank you. Agenda item 2, instruments subject to affirmative procedure, the Renewables Obligation Scotland Amendment Order 2013 draft. There is an error in Article 7, which inserts new Article 22C of the Principal 2009 Order in relation to electricity generated by certain types of biomass station. The new Article 22C2 refers incorrectly in two places to qualifying heat and power station. Combined heat and power station. The correct definition in Article 2 of the Principal Order is qualifying combined heat and power generating station. Does the committee agree to draw the instrument to the attention of the Parliament on the general reporting ground in relation to a minor drafting error? Agreed. Does the committee also agree to note that the Scottish Government has undertaken to amend the error at the next available opportunity? Agreed. No points have been raised by our legal advisers on the Police Investigations and Review Commissioner Investigations Procedure, Serious Incidents and Specified Weapons Regulations 2013 draft, nor on the Police and Fire Reform Scotland Act 2012, Consequential Modifications and Savings Order 2013 draft, nor on the Local Government Finance Scotland Amendment Order 2013 draft. Is the committee content with these instruments, please?
Content.
Excuse me, is this the one that we can connect?
No. It's fine, thank you, Chair.
Okay. Agenda item 3, instruments subject to negative procedure. The Police Service of Scotland Police Cadets Regulation 2013, SSI 2013-42. Paragraph 1 of Part 3 of the schedule to the instrument appears to be defectively drafted, and that it refers to the Police Minimum Age of Appointment Regulations 2006, a statutory instrument which applies to England and Wales, rather than referring to the Police Minimum Age for Appointment Scotland Regulations 2006, as apparently was the case, was the Minister's intention.
Before you put the question to us, does the Government agree it is defectively drafted? What you've just said, it appears to be defectively drafted. I'm just wondering if the Government agrees. Do we know?
I think we've conceded that the Government believes it's defectively drafted, in the sense that it refers to the wrong legislation. I think that's in our notes. Yes, ma'am?
See?
Oh, right. Okay, in which case I think our advice is that they do concede there's an error. I think the defective drafting is our terms rather than...
No, it's just convener. We're putting on the record, it appears to be defectively drafted, whereas I think the reality is it is accepted that it's defectively drafted and possibly know,
Yes.
Sorry, let's be clear. That's the reporting ground that we believe it is
Right,
defectively
okay.
drafted.
that's fine.
The government, as I understand it, says that they believe there is an error. They don't have to specify the ground. They merely have to, I
Right.
think, have
So
acknowledged that
it
there
is
is an error.
accepted there's an error.
Yes.
That's fine, Convener. Thank you.
Okay. Does the committee therefore agree to withdraw the instrument to the attention of the Parliament on the reporting ground I, as the drafting appears to be defective?
Agreed.
Thank you.
Also should
Draw your attention to the 1968 Act where the Cadet Corps was established. Now I understand there is no new legislation to establish the Cadet Corps, and I think that it's a lost opportunity not including that within the current legislation. This is a historic service that the police force has maintained and established, and it's a good opportunity for a young to be involved with the police. And I think that losing that opportunity at this stage is perhaps a weakness, and perhaps you can just point that.
Well, can I thank you for your comments, but I think that's very much a policy matter, and I would encourage you to take that to your colleagues on the Justice Committee when they consider this, because I don't think that's anything to do with the drafting of this, although I understand your point.
Well, I think that clearly if we're going to transfer a service from local police force services to a national police force service, therefore we have not considered its continuation in any form, and I think it's an opportunity lost. And it may not necessarily just be an issue of policy. It may be an issue that someone somewhere has forgotten this important element.
Well, forgive me, even if they've forgotten, it's still a policy issue. It really is. It's not the drafting, and certainly not the technical drafting of the instrument we have in front of us. So it does really need to go to your colleagues on the Justice Committee, please. Does the committee also agree to recommend to the Scottish Ministers that they lay an amending instrument to address this defect at the first available opportunity?
Agreed.
Thank you. Mike?
Convener, that this is an instance, I think, of where had good practice been followed in consolidation, then we wouldn't now be in the situation that we are. And obviously this is a situation that's persisted for some time. I think it may be worth the committee noting in its annual report that this adds substance to the arguments that we continually make about the need to consolidate before it gets to this kind of situation.
Well, indeed. I mean, the note I have in front of me, perhaps you'd let me read it. The instrument saves and continues in effect the Police Cadets Scotland Regulations 1968, together with 13 relevant amending instruments, which makes your point, Mike. Article 2.3 of this instrument further modifies the 1968 regulations. It's accordingly extremely difficult to ascertain the terms and conditions of service of police cadets, as the Police Cadets Scotland Regulations 1968 have been amended extensively, are not available as an as amended form, save in an unofficial consolidation prepared by Scottish ministers, and are not freely available in electronic form, even in their original and unamended form. So I think that makes the point, which you've already made, Mike, that this is a bad example of a lack of consolidation. And the fact that it affects a small number of people is surely not relevant in principle. Okay. Does the committee therefore agree to draw the instrument to the attention of the Parliament on the general reporting ground?
Agreed.
Thank you. The committee may wish to note the Scottish Minister's intention to request that the Scottish Police Authority provide a consolidated form of the 1968 regulations to each of the police cadets transferring to the Police Service of Scotland. Does the committee agree to note that it would be preferable, in the interests of accessibility of the subordinate legislation made under the Police and Fire Reform Scotland Act 2012, had Scottish ministers simply consolidated the 1968 regulations rather than relying on the saving provisions of this instrument, coupled with the existence of an unofficial and unpublished consolidated document?
Agreed.
Okay. Turning now to the National Health Service Scotland Injury Benefits Amendment Regulations 2013, SSI 2013-52. New Regulation 18B1 delegates power to the Scottish Ministers to specify the period within which a claim for injury benefit must be made in order for entitlement to benefit to arise. This permits the specification of a substantive matter other than by subordinate legislation, and therefore without any scrutiny by the Parliament. While the Superannuation Act 1972 permits the delegation of functions, the committee may consider that it is unusual for substantive requirements to be delegated in this manner. The committee may wish to note that this approach is inconsistent with the new regulations 18A2 and 21A1, which set out substantive time limits within the regulations. Does the committee agree to draw the instrument to the attention of the Parliament on reporting ground G, as the instrument has been made by what appears to be an unusual or unexpected use of the powers conferred by the parent statute?
Agreed.
The meaning of injury allowance in new regulation 411 could be clearer, since the NHS Terms and Conditions of Service Handbook, by which this term is defined, is not fully identified by reference to the source of the material and where copies of it could be consulted. Does the committee agree to draw the instrument to the attention of the Parliament on reporting ground H, as the meaning of injury allowance in new regulation 411 could therefore be clearer?
Agreed.
The handbook to which the Scottish ministers intend to refer was not in existence at the time when the instrument was made, nor when it was scrutinised by the committee. It was therefore not possible for the committee to discharge its scrutiny function as it would have wished. Does the committee therefore agree to draw the attention of the League Committee to the fact that the terms and conditions affecting entitlement to injury allowance in respect of work-related injury or disease sustained or contracted after the 31st of March 2013, which have been removed from the current statutory scheme, was neither defined nor published at the time the instrument was made?
Agreed.
Instead of that person, regulation 18B3 should have referred to the person making the claim. The government has undertaken to correct this provision when the principle or regulations are next amended. It's not clear when this will occur, or indeed whether it will occur at all, given that the effect of the regulations is to close the scheme in respect of injuries or disease sustained or contracted after the 31st of March 2013. Does the committee therefore agree to draw the instrument to the attention of the Parliament under general reporting ground, as a regulation 18B3 contains a minor drafting error?
Agreed.
Does the committee also agree to recommend that the government considers correcting this error in early course?
Agreed.
No points have been raised by the legal advisers on the Electricity Applications for Consent Amendment Scotland Regulations 2013, SSI 2013-58, nor on the fees in the Registers of Scotland, Consequential Provisions Amendment Order 2013, SSI 2013-59, nor on the Police Service of Scotland Conduct Regulations 2013, SSI 2013-60, nor the Police Service of Scotland Senior Officers Conduct Regulations 2013, SSI 2013-62, nor on the Education School Lunches Scotland Amendment Regulations 2013, SSI 2013-64. Is the committee content with these instruments, please?
Content.
Thank you. Agenda item 4 is Scottish Law Commission reports. The purpose of this item is to consider correspondence from the Standards, Procedures and Public Appointments Committee in relation to Scottish Law Commission bills. Members have the correspondence before them, along with a briefing paper from the clerk. The Standards Committee will consider the matter again at its meeting on the 14th of March and have asked for a response by tomorrow, Wednesday the 6th of March. Therefore, it would be best if any comments were agreed upon today. I suggest that we respond that we're content with the proposed standing order rule changes. Does anybody have any comment? No. Okay. With regard to the committee seeking policy input from subject committees, I'm suggesting that it is not appropriate for a timescale for input to be specified. Currently, to be honest, committees work well together on an informal basis, and I see no reason to put in a specific time. I don't know whether members have any comment on that.
Just a very brief, Chair.
That is that although we are not suggesting a time frame, surely there's a wish list of by when we hope that a reasonable time will elapse.
And I'm sure the committee clerks would be capable of agreeing that. I mean, I think they would normally expect a response within a few weeks. I don't know whether...
Convener?
Yes. Still.
I think given that the circumstances we describe are where we have been given a piece of Scottish Law Commission work to do in the expectation that there is no policy content, and we get to a point where we believe that there may be policy issue arising. It is not, of course, for us then to probe that in detail. It's for the lead committee whose policy it is. And I think, therefore, we would not readily be in a position to come to a view as to how big an issue it would be. It would be for the lead committee, who might conclude it was substantial or might very quickly conclude it was of a matter of quite substantial triviality. So I think we're not well placed ever to be able to put a timescale on things. I think we should, as a matter of good practice, probably indicate when it would be useful to our processes to have a response, but certainly not to get ourselves in a position where there is a locked-in timescale, because we aren't attempting to assess the policy issue, which we are raising as a question. So I think that's precisely why it's appropriate not to formalise the schedule, because it's really only the policy committee that can come to a conclusion rather than ourselves. So I agree that we should not formalise a timescale.
Thank you for that eloquent justification. Hansel?
Sorry, I
Disagree with that, because the whole point of an item coming to this committee is because it was being held up at the Justice Committee. So the reason it comes to this committee is that we're trying to support the Justice Committee in trying to get things done sooner rather than later. And therefore, I think anything that we send back to any committee, I think what it should happen, it should go on top of their agenda so that that process is successful. If we are sending something to a committee who are then going to put it into their scheme of things, if one can use that phrase, then that whole aspect of trying to clean up the backlog, we will not succeed in, because there will be a backlog of a backlog of a backlog. And therefore, when I say there should be a reasonable time, what I'm suggesting is perhaps if we send something back to a committee, they actually put it onto the next agenda to try and speed up the whole process so we can be successful in clearing the backlog. It is just a suggestion, Chair, at this stage.
Can I observe, first of all, entirely endorse your thoughts, because I think basically you're absolutely right. I am just conscious that sometimes, I think Stuart has eloquently put, that sometimes they will come to the conclusion that it is trivial and they really won't be worried about it. Sometimes they will draw the conclusion that there might be a significant policy in there, and they'll actually have to stop and think about how on earth they address that policy issue, because by definition we didn't think there was a policy issue to start off with. Thirdly, I would merely make the point that sometimes the Justice Committee, or indeed any other committee perhaps, might be looking at an extensive stage 2 schedule where actually they just couldn't fit it in. So I think we do have to be slightly careful not to put something in standing orders that we might instantly regret. There aren't going to be too many of these bills. Okay, I'm not in a hurry to suggest we put something in standing orders which we might subsequently realise just wasn't helpful.
Yeah, I'm not wanting to be unreasonable. I don't want to over-gild the lily, but what I'm saying is, I don't then want this committee to be a committee who has a backlog, because other people have not supported what we're trying to do. And I will leave that discretion to you, the Chair, as what you think is the best method of achieving that. But the whole point is, if people are asking this committee to take on additional responsibility to try and support, to clear up the backlog, what we don't want to do is to add to that backlog. That's all I'm saying, Chair.
Yeah, with you. Okay,
thank you.
I think perhaps we're forgetting that, of course, the timetables for each stage of a bill are set by Parliament on a motion from the Business Bureau. So it is not as if the process is without time constraints. So therefore, I think the need to set additional time constraints beyond, because at the end of the day, it may be, and it has happened in the past, that a committee has to go to the Bureau and say, this cannot be done in the timetable, Parliament has agreed, and Parliament has to take another decision. So I think there is a timetable, and we shouldn't fail to spot that that's the case, but it's done by a different process.
Yeah. Okay. I'm getting the sense, and it's largely about what people are not saying, that we're not arguing for a period of a particular period of weeks. And quite frankly, I suspect, like quite a number of things in this process, we're going to have to learn as we go along. We're only going to be doing these one at a time. We're not going to be doing terribly many in a hurry. So let's just see where we get to. But I think there's a sense that nobody's arguing for a period of particular weeks. Could we then just move on to, we also need to give our thoughts a possible name change to reflect the committee's new role. I have to say that I'm personally all in favour of that. I can't see any reason for having a name that's wrong. When we know something's changing, let's at least reflect it. My proposal, as the clerk had previously suggested, is that we might call ourselves the Delegated Powers and Law Reform Committee, not because we're the only people who ever consider delegated powers or the only people who ever do law reform, but that would cover the two things which we're being asked to do in the future. I just wonder whether anybody has any thoughts on that.
Agreed.
Be happy with that? Okay, let's see what other people want to say on that. Thank you. I think that brings us to the end of that item and therefore to the meeting. So thank you for your swift progress. Our next meeting will be next Tuesday. Thank you very much.